land from time immemorial. And further give thanks to Chippewa Saugeen and Chippewa Nawash, now known as the Saugeen Ojibwe Nation, as the traditional keepers of this land. We also recognize the Métis and Inuit whose ancestors shared this land and these waters. May we all, as treaty people, live with respect on this land and live in peace and friendship with all its diverse people. Approval of agenda. Madam Clerk, I believe you have a friendly amendment.
Staff would like to request that the agenda be amended to move item 5.1.8. That is PL 2022-47 to unfinished business.
Thank you. Is there any other additions or amendments? Seeing none, the recommendation is that the agenda be approved as amended. I need a mover to put on the floor, please. Moved by Councillor Coburn, second by Councillor Pringle. Is there any discussion on the motion before us? Seeing none, a show of hands, all in favor? The motion is carried. Declaration of pecuniary interest, you can declare anytime you see fit during the meeting. Minutes of the previous minutes. The recommendation is that the minutes of the Committee of Adjustment meeting held on July 19th, 2022 be approved. Someone to move to put on the floor, please. Moved by Deputy Mayor Carlton, second by Councillor Pringle. Any discussion on the motion before us? Seeing none, the show of hands, all in favor? The motion is carried. So we have a heavy agenda here today, so I'm going to move right into our first public meeting. This is a meeting of the Consent Committee of Adjustments to consider the application minor variance for Andrea Weir under Section 45 of the Planning Act regarding property located at 1242 Sunset Boulevard. Madam Deputy Treasurer, please go ahead with your review.
Thank you, Chair. There have been no requests for deferral or withdrawal of this application. Notice of this minor variance hearing in accordance with Ontario Regulation 200/96 made under the Planning Act was given on July 15th, 2022 by ordinary mail to all property owners within 60 meters of the property, which is subject to the application, and to all the required agencies. Notice was also posted on the subject lands and the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the Committee. Only a person or public body that requests a notice of decision of the Committee in respect to this proposed minor variance may submit an appeal.
Thank you, Madam Treasurer. Student Ben, can you please present the application? Ben, please go ahead.
Yes, thank you, Mr. Chair. The minor variance application A-08-22 seeks relief to Table 5.1 of the Township Zoning Bylaw to permit a garage to be built in the front yard of the property. The variance has been found to satisfy the four tests of a minor variance, and it is recommended that the application be approved. So for the four tests of a minor variance, number one, the variance must be minor. The subject lands are zoned residential for residential uses, and the applicant is proposing to build a garage adjacent to a residential structure. Garages are permitted as an accessory structure as per the bylaw. The placement of the garage on the subject lands is to be in a similar manner to neighboring properties and is expected to have no negative impact on the character of the neighborhood. So second, it must be an appropriate or desirable use of the land, building, or structure. The subject lands are zoned for residential purposes. The owner is proposing to build an accessory structure, a common and acceptable use for residential properties. The variance is expected to facilitate an appropriate and a desirable use of the lands. Third, it must maintain the general intent and purpose of the official plan. Inland, lake, and shore designations allows residential development. The subject lands are designated in Escarpment Recreation Area and Niagara Escarpment Plan Area on Schedule A of the Grey County Official Plan, GCOP, 2019. It is noted that the subject lands are zoned for residential uses and generally permit the construction of an accessory structure on the lands. The NEC provided no comments or concerns with the proposed application. 4, it must maintain the general intent and purpose of the zoning bylaw. With respect to the subject yard, the proposed structure will be appropriately accommodated on site, and further, the variances are not expected to negatively impact the use or maintenance of Sunset Boulevard, resulting in minimal impact to the visual character of the area. The variance upholds the general intent of the zoning bylaw. So the notice of complete application and public hearing was circulated to all required agencies. The following agencies' comments were received by the report submission deadline. So the County of Grey Planning and Development commented, and providing positive comments and received from the Niagara Escarpment Commission, county planning staff have no comments or concerns with the subject application. And the county requests notice of any decision made on the application with respect to this file. Grey Sauble Conservation Authority notes that the proposed detached garage lies within a regulated area. However, a permit under Ontario Regulation 151-06 was issued on March 30th of 2022 for the construction of a residential dwelling, driveway, and detached garage on the property. The permit was valid until March 30th of 2024. GSCA requests notification of any decisions and appeals filed. Grey Sauble Conservation Authority Risk Management Office and comments noted that the property is within a vulnerable source protection area where policies under the Clean Water Act, therefore storage of fuel greater than 8,000 liters is regulated, and if any activities and operations on the property change, to please contact their office. The Niagara Escarpment Commission provided no comments or concerns for the application. The notice of a complete application and public hearing was circulated to all properties and owners within 60 meters of the adjacent property. And at the time of writing the report, no written correspondence was received from adjacent property owners. In conclusion, the variance has been found to satisfy the 4 tests of a minor variance and is recommended that the application be approved. Thank you.
Thank you, Ben. No member of the public registered with the clerk to provide comments in support of or in opposition to the applicant. The applicant is not present here tonight. Jen, please go ahead.
Mr. Chair, the applicant is here. Amanda Weir is present this evening.
Oh, sorry. I'm reading my script. Welcome. Do you have any comments?
Basically, it is literally just a car garage for seasonal vehicles is what they're doing in storage.
Okay.
That's all it is.
Thank you. Does the committee have any questions? Deputy Mayor Carlton.
Yes, thank you, Mr. Chair. So is this in addition to the detached garage that's showing here with Grey Sauble, or is, like, I'm taking it this is a fairly new build and we're adding a detached garage already? It's saying in the Grey Sauble permit issued for a residential dwelling, a driveway, and a detached garage. Is this another one, or am I confused on this one?
Madam Clerk or Treasurer?
It is so the house has an attached garage. When we submitted the permits for the house to Grey Sauble, we had it drawn with the detached on there as well. So it is in addition to what is drawn on the survey.
Okay, so Grey Sauble approved it with that, but it didn't go through the township that way. I guess that's what's confusing me is where.
The blueprints weren't fully completed. We submitted partial blueprints of it to Grey Sauble based on the size and the height and all that requirements. They passed it by that.
Okay, thank you. So then why is it coming through separately at the township, Madam Planner?
Thank you, Member Carlton. It's coming separately because the house that was proposed received a building permit because it complied with zoning. This structure doesn't comply with zoning because the zoning doesn't permit you to build a detached garage in what we consider to be the required front yard. And that's why the minor variance is required.
Okay.
Okay, thank you.
Thank you, Madam Planner. Is there any other questions from the committee? Seeing none, I'm going to read the recommendation. Minor variance application A0822 to permit a non-havable 44.6 square meter, 480 square feet detached garage to be built in the front yard satisfies the 4 tests of minor variance as required by the Planning Act RSO 1990 P13. It's recommended that application A0822 be approved. Someone to move to put it on the floor, please. Moved by Member Carlton, second by Member Pringle. Is there any further discussion on the motion? Seeing none, a show of hands, all in favor? The motion is carried. No further discussion. I'll now call for an adjournment of this public meeting. Moved by Councilor Pringle, second by Deputy Mayor Carlson. Do we adjourn? Show of hands, all in favor? We are so adjourned. Moving on, our next minor variance. This is a meeting of the Committee of Adjustment to consider application for minor variance for Reginald McDonald Holdings under Section 45 of the Planning Act regarding property located at 281 Balmy Beach Road. Madam Deputy Secretary Treasurer, please go ahead.
Thank you, Chair. There have been no requests for deferral or withdrawal of this application. Notice of this minor variance hearing in accordance with Ontario Regulation 200/96 made under the Planning Act was given on July 29th, 2022 by ordinary mail to all property owners within 60 meters of the property, which is subject to the application and to all required agencies. Notice was also posted on the subject lands and the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the Committee. Only a person or public body that requests a notice of decision of the Committee in respect to this proposed minor variance may submit an appeal.
Thank you. Madam Planner, please go ahead with your review.
Thank you, Mr. Chair. So this application requires a minor variance to increase the front yard projection allowance to accommodate a deck. So what's being proposed is the application proposes to allow a deck to project 4.5 meters into the required front yard, as opposed to the 4 meters that's specified in the zoning bylaw. The application also proposes to increase the total permitted lot coverage from 20% to 25%, and that will facilitate the construction of a new detached dwelling on the property. So this is a half-acre waterfront lot, and it fronts onto Balmy Beach Road. And it's actually a redevelopment of the property. There's currently a cottage on site, and that would be demolished to accommodate the new build. The lands are designated inland lake and shoreline under the county official plan, and they're zoned shoreline residential. So both that designation and that zoning permit residential development. So the surrounding land uses include developed and undeveloped shoreline residential parcels, and Georgian Bays to the east and rural lands in the Niagara Escarpment to the west. The application did come before the Committee of Adjustment on the 19th of April, and it has since been recirculated as moving through the process. It was discovered that additional relief, and that's the relief to the front yard projection, was required for this application, as well as there's a 1% increase into the total lot coverage than was initially proposed. So as we know, has been explained, for a for a variance to be determined minor, there are 4 tests that must be met. It must be minor. It's an appropriate or desirable use of the land, building, or structure. It must maintain the general intent and purpose of the official plan, and it must maintain the general intent and purpose of the zoning bylaw. So as indicated in the report, the application does satisfy the tests, 4 tests of a minor variance. So the comments we received on this application included comments from the county planning department. They provided us noting that they have reviewed the revised minor variance application and provided the proposed dwelling is located outside of the mapped hazard lands, and positive comments are received from the Conservation Authority regarding proximity to Georgian Bay and the significant woodlands across the street. They generally have no concerns with the subject application. The Conservation Authority provided comments indicating that they did comment on the original proposal and requested an engineered lot grading and drainage plan, and they wanted an accurate depiction of the 100-year lake flood level for consideration. So they wanted to know that that proposed dwelling was outside of that flood line. That engineered plan was completed by GM Blue Plan and submitted and reviewed, and the Conservation Authority is satisfied that the proposed development is located outside of that hazard area, so they have no objection to that development. And they do note that with the implementation of appropriate sediment and erosion control measures, they're not anticipating negative impacts from this redevelopment of the property. And so drainage appears to be generally maintained and directed accordingly. And they determine that the application is consistent with provincial policy. They have no objection to the approval of the minor variance application. The Risk Management Office, they did note that the property is located within the Intake Protection Zone 2 for the East Linton drinking water system. And through that, the IPZ to mapping, fuel storage is regulated. So there shouldn't be any fuel storage within that area or with that property. Generally, with the residential development, there's no fuel storage associated. Excuse me. We circulated the application to all property owners within 60 meters of the subject property. And with the second circulation and with the revised application, we did not receive any comments. So the recommendation in the report is to approve the application. And I'd be happy to answer any questions that the committee has.
Thank you, Madam Planner. No members of the public registered with the clerk to provide comments in support of or in opposition to the applicant. The applicant is not present. Does the committee have any questions? See none, I'll read the recommendation. This minor variance found to satisfy the 4 tests of minor variance as required by the Planning Act RSO 1990 P13. It is recommended that application A0322 be requested relief from zoning bylaw 2020 to increase the front yard protection from 4 to 4.5 to accommodate a deck and to increase total permitted lot coverage from 20% to 25% to facilitate the construction of a new detached dwelling on the subject land be approved. Someone to move to put on the floor, please. Moved by Councillor Barfoot, second by Councillor Colburn. Is there any discussion on the motion before us? Seeing none, show of hands, all in favor? The motion is carried. I now need a motion of adjournment. Moved by Councillor Barfoot, second by Councillor Pringle. If there's no discussion on the motion before us, a show of hands, all in favor? The motion is carried. Thank you. Moving on for our next minor variance. This is a meeting of the Committee of Adjustment to consider the application consent for Smith Core Realty Incorporated, John Smith, under Section 53 of the Planning Act regarding a property located at 394 2nd Avenue Southeast, Owen Sound. Madam Deputy Treasurer, please give your report.
Thank you, Mr. Chair. There's been no request for deferral or withdrawal of the application. Notice of this consent in accordance with Ontario Regulation 19796 made under the Planning Act was given on July 26, 2022 by ordinary mail to all property owners within 60 meters of the property which is subject to the application and all the required agencies. Notice was also posted on the subject lands and the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the Committee. Only a person or public body that requests a notice of decision of the committee in respect to this proposed consent may submit an appeal. So this application did come before the committee in July 19th, 2022, and it was deferred based on new information with regard to the legal description of the property. So as it turns out, there is actually it's about a 1,000 square meter landlocked parcel located adjacent to the portion of the property that was that is the subject of the lot addition. So the application was amended by the applicant and resubmitted, and it's now proposing effectively a 1 hectare lot addition to that existing 1,000 square meter landlocked parcel. So that's what we like to see, is that we have a property that has direct access onto an open and maintained road. And then in this case, that would happen with that land transaction, should the committee approve it. So The proposed lot dimensions actually comply with provisions of the bylaw as authorized by a minor variance that was granted in June of 2012. So at that time, we did receive an application as was brought up through the previous comments that were raised by through the previous circulation, and the Township Committee of Adjustment approved the minor variance application A05-2011, which recognized the lot sizes for the severed and retained parcel, and it also recognized the location of the structures on the retained parcel in order to facilitate a severance. The Committee of Adjustment also approved the severance application to create the two lots. However, when the lawyers went to register and they were doing the paperwork, they found out that there was this 1,000 square meter parcel, and it turns out that it was created in 1977. So it's been there all this time, and I guess because it didn't show up in the mapping, it wasn't discovered until there was a full analysis of the legal description of that lot. Because quite often what we see in the information we get is a very general legal description. It's not specific unless there's been a number of transactions and the property's been sold. So, the report that was submitted, it does provide a policy review and supports the application for a lot addition in a settlement area. As I mentioned, that landlocked parcel was created in 1977, and it was approved by the County of Grey Land Division Committee, who was the land division authority at that time. So this application seeks to increase the size of that lot and to obtain road access and through the cul-de-sac. So the township, the previous consent approval, it did lapse because the lawyer for the township recommended that the application should proceed as a lot addition now that they were aware that there was a landlocked parcel. And so the application was left, and the owner at the time did not reapply for a lot addition. So when we looked at the policies as well, we note that the county official plan does contain a policy that requires where municipal services pass by a property, new development will not be permitted unless a connection can be obtained. So the area surrounding the proposed lot addition is serviced by municipal water from the city of Owen Sound. And with the assistance of Brian Anderson from the operations department, we did manage to find 3 bylaws that apply to this subdivisions surrounding this lot. So these are bylaws that address water connections to the municipal service. And those bylaws require the owners within the service area to connect to the water system. And the agreements note that users are responsible to pay water rates to the city of Owen Sound. And within each of those 3 bylaws that cover those subdivisions in that area, they all contain a provision that states any lots created by severance within the service area after the passing of this bylaw, or any lots that existed prior to the passing of this bylaw, excuse me, that were excluded from the Schedule C that identifies all of the lots that were subject to the bylaw, will also be subject to the same net capital costs as estimated in Schedule B. However, connection charge and contribution to capital for the city of Owen Sound may also be subject to change from time to time. So within the those bylaws, there's also an application form for any property owner to fill out and submit for a water connection. So it's clear that the intent of the bylaw was to provide for lots in that area to connect, whether they were existing and were missed, which is the case with this landlocked parcel, or if they were created after the fact by severance, which is the case for this lot addition. So what will have to happen is the applicant will submit that application to the City of Owen Sound for a water connection, and there will be some um, um, consultation with the township on that, because the township actually owns the road, and so we would have to enter into an agreement for the installation of a water service for the lot. So, and then I would note that we did have a look, and we could not find a bylaw to rescind or replace the bylaws that stated this requirement to connect. Also, the policy review does look at a review of the natural heritage features and hazards as identified by the Conservation Authority through their role as a service provider to the township. And their conclusion was that based on the site plan provided and the fact that there was no required tree removal because of the location of the proposed development, that there would be no negative impacts on the features that existed there. So they do recommend appropriate sediment and erosion control measures be implemented to minimize any potential impacts in the way of sedimentation. They did review the conceptual lot grading and drainage plan provided with the subject proposal, and it appears drainage will be accommodated appropriately through the use of swales towards the west side of the dwelling and a soakaway pit towards the eastern property line. And they're recommending a finalized engineered lot grading and drainage plan be provided with the submission of a permit application. They have requested that the entrance, which runs through the Kramer Municipal Drain, be designed by a qualified engineer to ensure that there is no impact to upstream and downstream properties. And then further detail would be required in regard to the laneway, and that can be addressed by them at the permitting stage. That entrance to that portion of the property is regulated by the Conservation Authority, and any development there requires a permit from their office. The property is zoned residential 1 and environmental protection, and as we noted before, there was a minor variance approved back in 2012, and it recognized the lot area and frontage for the severed and retained parcels, and it recognized the location of the existing structures on that retained parcel. So the property is ready for would be ready for the proposed severance. The zoning bylaw does allow a minor variance to be recognized where it is implementing what was approved by the minor variance. So the resultant lot sizes and the intent is exactly the same as what was approved by that minor variance back in 2012. All development on the severed lot will need to comply with the provisions of the bylaw in effect at the time that the permit is issued. So when they come forward, if the application is approved, when they come forward with a building permit application, they still have to comply with the lot area requirements and setbacks as well, because no relief has been granted for that at this time. So the relevant consultation, we circulated the application to various agencies. Hydro One had no comment. Enbridge Gas it does have service lines running through the area, which may or may not be affected by the proposed severance. If there needs to be any changes or gas terminations or relocates, it's done at the cost of the applicant, and they need to contact Enbridge Gas directly prior to any changes occurring. Bell Canada has no concerns. The Risk Management Office have no comment. Grace Harbor Conservation Authority provided comments dated July 8th and August 9th, noting generally no objections to the consent application. They recommend a finalized engineered lot grading and drainage plan be provided for the development, as well as the implementation of sediment and erosion control measures, the preservation of a vegetation buffer as well along the watercourse, and they require a permit for this proposal. They wish to be informed of any decision made by the Committee of Adjustment. The County of Grey Planning and Development Department, in comments, 2 sets of comments on the application. So they reiterated their comments for both circulations. There is a linkage identified on the property associated with the Kramer Municipal Drain, and they want that to be rezoned environmental protection to protect the integrity of the feature into the future. So that will be done. The Conservation Authority will provide us with updated mapping when we update our zoning bylaw. And so that will be addressed that way. So they want, there was some of the comments we received from the City of Owen Sound don't directly commit to providing a water connection. So the county would recommend that the application be refused until a connection to the municipal water can be achieved. Because we have those bylaws requiring the property owners and having the applications, the recommendation is not to refuse the application at this time. As a condition of severance, I'm recommending that the property owner apply to the City of Owen Sound for a water connection and obtain that in accordance with the bylaw that was passed by the Township of Georgian Bluffs, because that speaks to the water provision agreement that the township has with the city. An engineered entrance over the municipal drain be prepared and setbacks established per the comments received by the Conservation Authority, and that road widening be deeded to the county. I believe this is an error, as the county doesn't own the roads in that area. It's owned by the township, as well as I think a portion north is owned by the City of Owen Sound. So, so the City of Owen Sound did provide us with comments, and so their Public Works and Engineering Department reviewed the application, and they looked into the water connection, and a portion of the property on 2nd Avenue Southeast does have a water connection. It's just this severed parcel that is needing the water connection. And they note that the Maple Crest subdivision is also serviced with municipal water from the City of Owen Sound under an agreement between the city and the township. They are noting that because the lot isn't and the property is not specifically identified in a water service agreement that they have, they are recommending that the property owner apply, and that the township and the city would consider, the 2 councils would consider whether or not the agreement should be amended. Given that we have the bylaws that are requiring the connection, the intent was to allow for additional parcels to connect. So that's something that can be worked out through planning and operations with the City of Owen Sound. And then the property will be serviced by a septic system. So we did circulate this application the second time. It only required a 60-meter circulation because it was only a severance application. The first time the application went out, it went a circulation distance of 120 meters because it had an associated zoning bylaw amendment. And because the zoning bylaw amendment has a 120-meter circulation requirement, we take the furthest one and circulate that. So in this case, because the zoning amendment application was withdrawn, it went to the 60-meter required circulation distance. And we received comments from Catherine Kramer. Those comments are attached to the report for the committee's consideration. And she's concerned with the house being built on the property and cited environmental concerns and just a change in the neighborhood. We received comments from Spencer Curley, and he noted concerns with future road construction and the cul-de-sac that's actually delineated on the plan, as it impacts the existing parking for his fourplex. So we looked into that. The cul-de-sac was actually part of the original plan of subdivision, and it was just never built out. So that bulb was never paved out. So technically, Mr. Curley's tenants are parked on the road allowance, and as well, there's a drainage easement assigned to the township on a portion of that property, and that's also been paved over. So there are no plans through the application to alter that side of the street. However, Mr. Curley's parking situation has been forwarded to the operations department for review and comment, and they're going to follow up with him just to clean up that situation. So the recommendation in the report is to approve the application, subject to the conditions, the severance conditions noted within that report. And I'd be happy to answer any questions.
Thank you, Madam Planner. Spencer Curley, registered with the clerk to comment on the application. Mr. Curley, are you there?
Yes, I'm here. I'm clear. I don't have any questions. Thank you.
Thank you. The agent, Ron Davis, is present. Ron, please go ahead.
Yes, good evening, Mr. Chair, committee members. I shall be brief. Yeah, when we first filed the application, it was for a new lot. And then your staff here went through a file and found a legal opinion from 2012, I believe, that stated that, in fact, it was an existing lot of record. And that we should have been applying for a lot line adjustment, which is good news because, as you heard from your planner, the city is not obligated to supply water to a brand new lot, but they are obligated through your agreement or bylaw to supply water to an existing lot of record. So that's what we have here, an existing lot of record that we're expanding. So fingers crossed that the city of Owen Sound will live up to their that agreement. So that's really good news. Just quickly here, the one comment from the neighbor concerned about the natural environment. I will say this. One thing that wasn't mentioned was the fact that an engineering report was done before we filed the application. There's a little swath of environmental hazard land that cuts across the front of the property. Probably just a ditch. But anyways, an engineering report was done to the satisfaction of the Conservation Authority. The house will be pushed to the east side of the property and certainly not to the west side because, yes, there's some wooded area in there. And it's also within, I believe, the Niagara Escarpment Commission has a little bit of land in there as well. Or pardon me, a part of the subject property falls within the Niagara Escarpment area. So there shouldn't be any issues. If there were concerns with regard to the natural environment, you would have heard from the Grey Sauble Conservation Authority in that regard. That's it for my presentation. Thank you.
Thank you, Ron. Does the committee have any questions? Go ahead, Councilor Pringle.
Yeah, thank you, Mr. Mayor. Yeah, so the only question I really had, so the planned development is strictly just to build a house on this property. It's not looking at a development down the road or any other particular project. Just one house is going to be on this land.
That is correct.
So my question is then on the cul-de-sac piece then that we've been discussing, as it's been there forever and a day. Technically, at the end of the day, we just need a laneway that goes into that property then. Like, what's the deal with the why is that piece of the cul-de-sac have to change if we're just having a laneway that goes straight through the road?
If that's directed at me, and I certainly can't speak for Public Works, but yeah, that's exactly my point. I did speak with the gentleman when I saw his email,
right,
and because I thought maybe there was some confusion there.
Right.
And I think maybe sometimes when you see a road allowance and a cul-de-sac bulb on a drawing, people sometimes misconstrue the road allowance for the road. So you'll have this great big gigantic cul-de-sac bulb that is from one side to the other 40 meters wide. And that isn't changing. That's what's important here. And the paved portion inside there is a lot smaller. And I can't imagine why that would need to change. You're correct. The only thing that you're going to see different will be one brand new driveway running from the edge of the paved road into this lot.
Thank you.
Thank you. Madam Planner, a question for you. I realize that the city of Owen Sound and water connections, that could be a discussion with them to get them to honor the agreement with George Bluffs to do with that subdivision and so on. If there's a big long battle, does it slow the applicant up?
So the conditions of approval are valid for 2 years. So the applicant has 2 years to get all of their conditions met, have all of their conditions met. Discussions with the city of Owen Sound, given that staff could start right away with their engineering department and provide some documentation for them to review, and the applicant can submit an application. And then if it is something that requires consideration by both councils, then obviously it would be brought before the new term of council, given that there's not enough time for this to be resolved before the final meeting of this council.
Thank you. Any other questions from the committee? Seeing none, I'm going to read this recommendation. It has been demonstrated that application B1322 for Smith Core Realty for lands described as Lot 55, Part Lot 56, Derby is consistent with the provincial policy statement 2020. The county gray official plan, recolor gray, and the intent of the towns of George Bluffs zoning by law 2020. It is recommended that application be approved subject to the following conditions. 1, the reference plan be completed and a copy filed with the municipal clerk, or exemption from the reference plan be received from the land registry office. 2, that pursuant to section 5342 of the Planning Act, the certificate of consent be affixed to the deed within 2 years of giving the notice of decision. Note, consent must be carried out within 2 years of the issuance of the certificate, that is, stamping of the deeds. 3, that the applicant is for a lot addition only, and the lands be severed, be merged under the same ownership as the abutting lands. Part Lot 56, Plan 528, Part 1, Plan 16R 1058, and that subsection 3 or 5 of Section 50 of the Planning Act apply to any subsequent conveyance. A copy of the registered deed to the abutting lands, Part Lot 56, Plan 828, Plan 1, 16R 1058, shall be filed with the Township of George Bluffs Committee of Adjustments. 4, that the applicant pay the applicable consent certificate fee at the time of certification of deeds. 5, that the applicant pay the applicable consent cancellation fee at the time of certification of the deeds. 6, that the applicant enter into a water service agreement to or obtain a water connection from the city of Owen Sound for the severed parcel. Someone to move to put on the floor, please. Moved by Deputy Mayor Carlton, second by Councillor Colburn. Is there any discussion on the motion before us? Seeing none, show of hands, all in favor? The motion is carried. I'll now call for adjournment of this public meeting. Moved by Councillor Barfoot, second by Councillor Pringle. Show of hands, all in favor of adjournment? The motion is carried. Moving on, this is a meeting of the Committee of Adjustment to consider the consent for Connie Wilcox under Section 53 of the Planning Act regarding property located at 279268 Cabell Side Road. Madam Deputy Treasurer, please go ahead.
Thank you, Mr. Chair. There have been no requests for deferral or withdrawal of this application. Notice of this consent in accordance with Ontario Regulation 197/96 made under the Planning Act was given on July 26, 2022 by ordinary mail to all property owners within 60 meters of the property which is subject to the application and all the required agencies. Notice was also posted on the subject lands in the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the Committee. Only a person or public body that requests a notice of decision of the Committee in respect to this proposed consent may submit an appeal. So this application effectively proposes to create a 2.5 acre non-farm residential parcel from a 100 acre lot. The proposed and retained lots both meet the provisions for lot area and frontage in the township zoning bylaw, so there's no need for an associated zoning amendment application. Schedule A of the county official plan locates the subject lands within a rural designation, with a portion in the southwest corner abutting the Sarawak-Keppel town line being designated hazard. This land use designation, the rural designation, permits limited non-farm residential lot creation. No previous severances have been taken from this original 100 acres, and therefore the proposed severance could be considered by the committee. The proposed lot area and frontage also meet the intent of the county official plan policies. So there's a small portion of significant woodland immediately west of the proposed lot, and the Conservation Authority have identified the potential for endangered species and threatened species, noting that as the proposal is within an agricultural area and development of the lot will not require any tree removal, they are of the opinion that there will be no impacts to the significant woodland feature. The property has the potential to support endangered species and threatened species, and the noted species are bobolink and eastern meadowlark, and that's within any given year. So they recommend that the Ministry of Environment, Conservation and Parks be contacted should those species be encountered. They anticipate that development will result in an increase in site imperviousness. However, note that the rural nature of the area and they don't anticipate any negative impacts because of that rural nature of the area. An engineered grading and drainage plan with site-specific development to address potential lot drainage issues is recommended at the time of the building permit application. The Conservation Authority identified natural hazard features on the property to include flood and erosion potential associated with the watercourse and wetland features. And they do note that portions of that property are regulated, and a permit is required for any development or alterations with any regulated area. We did calculate minimum distance separation for 3 barns within the 750 meter required investigation distance. And the location of the proposed lot exceeds the calculated minimum distance requirement of all 3 of those livestock operations. So where it's being proposed is located sufficiently outside of that setback arc. The proposed lot area is 2.47 acres, and the frontage is 100 meters. And as I mentioned, they comply with the rural zone provisions for a privately serviced lot. So the application was circulated to various agencies for comment. The Conservation Authority has no objections to the application as it is not anticipated to impact any natural hazards, natural heritage, or areas under Ontario Regulation 15106. They recommend contacting the Ministry of the Environment, Conservation and Parks should any bobolink or meadowlark be encountered prior to development occurring. And they also recommend a grading and drainage plan be submitted to the township with site-specific development proposal at that building permit stage. The County Planning Department defer to the Conservation Authority for positive comments regarding the streams and significant woodlands. The staff have no concerns with the subject application, and they do request to be notified of any decision rendered with respect to this file. Hydro One has no concerns, and Enbridge Gas does note they have service lines in the area. Service location is at the cost of the property owner, and Enbridge Gas needs to be contacted prior to any site alteration. The Risk Management Office had no comment, and we circulated the application as required to all property owners within 60 meters. We did not receive any written comments by the report submission deadline. So the recommendation is in the report is to approve the application subject to the conditions that are noted in that report. And I'd be happy to answer any questions that the committee may have.
Thank you, Madam Planner. No one registered with the clerk to comment on this application. Does the committee have any questions on this application? Seeing none? The recommendation is, it has been demonstrated that the application B1922 for Connie Muzzle Wilcock for lands described as Concession 1, Lot 29, Sarawak is consistent with the provincial policy statement 2020, County of Gray official plan recolored gray, and the 10th of the Township of Georgian Bluff zoning bylaw 2020. It is recommended that the application be approved subject to the following conditions. 1, the reference plan be completed and a copy filed with the municipal clerk or an exemption from the registered plan be received from the land registry office. 2, that pursuant to section 5342 of the Planning Act, the certificate of consent be affixed to the deed within 2 years of the given of notice of decision. Note, section 5343 of the Planning Act requires that a transaction approved by this consent must be carried out within 2 years of the issuance of certificate, that is stamping of the deed. 3, that the applicant pay the applicable consent certificate fee at the time of certification of the deeds. 4, that the applicant pays 5% cash in lieu of parkland in accordance with the Planning Act. Someone to move to put on the floor, please. Moved by Councilor Pringles, second by Deputy Mayor Carlton. Is there any discussion on the motion before us? Seeing none, let's show of hands, all in favor. The motion is carried. Now I ask for an adjournment of this public meeting. Moved by Councilor Colburn, second by Councilor Barfoot. There's no discussion. The show of hands, all in favor of adjournment. We're adjourned. Thank you. Moving on to our next public hearing. This meeting of the Committee of Adjustment to consider the applicant consent for Barry and I'm going to say Lee Vincent under Section 53 of the Planning Act regarding property located at 017877 Gray Bruce Line. Madam Deputy Secretary Treasurer, please go ahead.
Thank you, Mr. Chair. There's been no request for deferral or withdrawal of the application. Notice of this consent in accordance with Ontario Regulation 19796 made under the Planning Act was given on July 21st, 2022 by ordinary mail to all property owners within 60 meters of the property, which is subject to the application, and to all the required agencies. Notice was also posted on the subject lands and on the Township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the Committee. Only a person or public body that requests a notice of decision of the committee in respect to this proposed consent may submit an appeal. So Barry and Lee Vincent own 200 acres fronting onto the Grey Bruce Line. So what they're proposing is to sever off 97 acres. They effectively own all of lot 15 on concession 12. That is in Derby and was originally surveyed as a 200-acre lot. So they have a 3-acre parcel that was created a number of years ago. And what they wish to do is take 97 acres, add it to that 3-acre lot, and then they would end up with 2 100-acre parcels. So that lot addition would then create 2 100-acre farm parcels. The application is supported by the County of Gray agriculture policies because of the resultant lots. The county mapping does indicate the property is designated agriculture, hazard, and provincially significant wetland. And it does contain karst in the northeast portion of the property that falls within the PSW feature, the provincially significant wetland. Because there's no development proposed or possible within that PSW, so a karst assessment is not required. The property also contains significant woodlands, other identified wetlands, and a stream. No development is proposed through the application. And when you look at the configuration of the property, so the resultant 100-acre parcel that would not contain a dwelling, that would be vacant, there is sufficient room on that property to build a house outside of any regulated area or setback to the provincially significant wetland or an EP zone. And I would reiterate, no development is being proposed at this time. The county official plan under Appendix E also indicates the presence of bedrock on the eastern portion of the lands within that PSW, as well as the front 400 meters of the property. And because there's no development proposed, the county did not require a bedrock assessment as part of the application. So the proposed lot addition results in lots that do meet the provisions of the zoning bylaw. Enbridge, through our circulation process, we received comments back from Enbridge Gas. There are gas lines in the area. Should a relocation be required, it would be at the cost of the property owner, and they need to contact Enbridge Gas prior to any site alteration. Hydro One had no comments or concerns. The Grey Sauble Conservation Authority had no objections to the approval of the subject consent application, as it's for lot addition purposes, and the overall development potential of the lots are unchanged from the present situation. They did note that there is potential with this proposed lot configuration for a portion of the southerly lot to be landlocked. So because of the PSW feature, the property owners may not be able to access a back portion of the property. They would need to go through the severed portion to get into the back portion of the retained. So they note that while this is not prohibitive of the application moving forward, they feel it's necessary to advise the applicant of this. They also note that the result of the lot addition will be 2 100-acre farm parcels. They would like to point out that much of the property is zoned environmental protection, and it does feature that provincially significant wetland. Only a portion of the property is zoned agricultural and designated agricultural in the official plan. So they just wanted to be clear that it's not, the creation of these 2 lots does not create 2 full agricultural designated or zoned parcels, but they're 2 parcels that do contain a significant amount of provincially significant wetland. The County of Grey Planning and Development Department state that there are no concerns with the proposal. Provided positive comments are received from the Conservation Authority regarding the PSW, the hazard lands, other wetlands, streams, and significant woodlands. And it is determined that an EIS is not required. County planning staff have no concerns with this subject application, and they request to be notified of any decision rendered with respect to this file. Because the property is on the boundary between Bruce County and Grey County, we circulated Bruce County as well as Aaron Eldersley for comment. We received comments back from the engineering manager for the County of Bruce, and he noted that if a new entrance is proposed, the applicant will require the appropriate entrance permit. And the County of Bruce did not have further comments on the application. We circulated this application to all property owners within 60 meters, and we did not receive any written comments back. So as noted in the report, it's recommended that the application be approved, subject to the conditions that are noted in the report. And I'd be happy to answer any questions that the committee may have. Thank you.
Thank you, Madam Planner. Brian Lee Vincent, the applicant's register of the clerk to comment. Please go ahead. Who wants to comment?
No, we're here, but we have no comment at this time. Thank you, sir.
Thank you. Does the committee have any questions? Seeing none? I'll move ahead with the recommendation then. It has been demonstrated that application B1722 for Vincent for lands described as concession 12 part lot 15 Derby is consistent with the provincial policy statement 2020, the County of Grey official plan, recolor gray, and intent of the Township of Georgian Bluffs zoning bylaw 2020-20. It is recommended that the application be approved subject to the following conditions. 1, that a reference plan be completed and copy filed with municipal clerk, or an exemption from the reference plan be received for the land registry office. 2, that pursuant to section 5342 of the Planning Act, the certificate of consent be affixed to the deed within 2 years of giving of the notice of decision. Note, section 5343 of the Planning Act requires that the transaction approved by this consent must be carried out within 2 years of the issuance of certificate, that is stamping of the deed. 3, that the application is for lot addition only, and that the lands to be severed be merged under the same ownership as abutting land, concession 12, lot 15 RP 16 R 2242 part 1, and sections 3 or 5 of the section 50 of the Planning Act apply to any subsequent conveyance. A copy of this registered deed to the abutting lands, concession 12 part lot 15R 16R 2242 part lot 1, be filed with the Council of Georgian Bluffs Committee of Adjustments. 4, that the applicant pay the applicable consent certificate fees at the time of certification of the deeds. 5, that the applicant pay the applicable consent fee at the time of certification of the deeds. Someone who would put on the floor, please. Moved by Deputy Mayor Carlton, second by Councillor Pringle. Is there any discussion on the motion before us? Seeing none, a show of hands, all in favor? The motion is carried. I'll now need a motion to adjourn, please. Moved by Councillor Pringle, second by Councillor Barfoot, that we adjourn. Show of hands, all in favor? We adjourn. Thank you. Moving right along. This is a meeting of the Committee of Adjustment to consider application for consent for Zachary Taylor and Taylor Christie under Section 53 of the Planning Act regarding property located at 404197 Concession 20. Madam Treasurer, please go ahead with your report.
Thank you, Mr. Chair. There have been no requests for deferral or withdrawal of the application. Notice of this consent in accordance with Ontario Regulation 197/96 made under the Planning Act was given on July 22nd, 2022 by ordinary mail to all property owners within 120 meters of the property which is subject to the application, and to all the required agencies. Notice was also posted on the subject lands and the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary-Treasurer of the Committee. Only a person or public body that requests a notice of decision of the committee in respect to this proposed consent may submit an appeal.
Go ahead, Madam Planner.
Thank you, Mr. Chair. So this application is to create a 1.24 acre privately serviced residential lot in Kemble. Kemble is designated as a secondary settlement area in the County of Grey official plan. And while the majority of this lot is within the agricultural designation, a portion of it does fall within the settlement area boundary where policies permit residential lot creation. The report provides a policy review and notes the applicable policies in considering this application. And in addition to the comments received, the policies support what's being proposed. Staff note that Grey Sauble Conservation Authority comments indicate that the property has the potential to support bobolink, and they recommend that the Ministry of the Environment, Conservation and Parks be contacted should these species be encountered. The proposed severance is located northwest of the intersection of Kemble Rock Road and Concession 20. We know that drainage is an issue in Kemble, and through their review of the applications, the Conservation Authority is recommending an engineered grading and drainage plan with the site-specific development. So the building department will require this as part of a complete application. There were no natural hazards identified on the property at the time of the review, and the subject lands do contain areas regulated by the Conservation Authority. The portion of the property subject to the severance will need to be rezoned to an R1. Right now it's a planned development zone. Or excuse me, it's zoned, I believe it's zoned agriculture. and that rezoning will facilitate the severance. The application to consider the zoning is being held tomorrow night, August 24th. So we received the following comments back from the agencies. The Conservation Authority has no objections to the subject consent and zoning bylaw applications, as they are not anticipated to impact any natural hazards. They recommend contacting the Ministry of the Environment, Conservation and Parks should either bobolink or meadowlark be encountered prior to development occurring. Excuse me. They recommend a grading and drainage plan be submitted to the township with a site-specific development proposal at the building permit stage. The County Planning Department note that provided municipal staff are satisfied that the proposed lot and any future lots can be sustainably serviced by private servicing, they have no further concerns. The Risk Management Office have no comments. Hydro One has no comments. And the application was circulated to all property owners within 120 meters of the subject property. We received comments back from David Johnson, and Mr. Johnson expressed concern with drainage in Campbell. He has no issue with the creation of a lot in the northernmost area of the lands, subject to the rezoning, but he does not support additional lot creation within that southern area of the property being rezoned, so closer to the intersection of Campbell Rock Road and Concession 20. So the recommendation in the report is that the severance be approved, subject to the conditions noted in the report. And I'd be happy to answer any questions that the committee may have.
Thank you, Madam Planner. No one registered with the clerk to comment on the application. Does the committee have any questions? Councilor Colburn, please go ahead.
Thank you, Chair Burley. And I guess I have two comments. One of them is specific and probably more relevant, and the second one is perhaps a little more philosophical for council to consider maybe at a different time. So through you, Chair Burley, to our senior planner, I just want to be very clear in your reassurances regarding drainage here. You're going to hear me say this again tonight, but once bitten, twice shy. I think, we keep talking about effective drainage plans being put in place, and we expect that to happen, and it is, and we see resultant negative outcomes to surrounding neighbors. I just want to be really clear that we're sure that this isn't going to impact the flooding issue in Campbell at this time. So that's my first question.
Madam Planner, is this not a discussion for tomorrow night to do with the actual drainage part?
Mr. Chair, so the drainage can be considered at any time. Generally, the Conservation Authority, as a service provider to the township, they review drainage concerns as part of their review, which is why it's noted in their comments. So the application as well at the building permit stage would require an engineered grading and drainage plan. So moving forward in the future, if the committee would prefer to have some documentation from an engineer on this application, then that can be requested of the applicant, or as the the Conservation Authority's comments say, the drainage plan is required at the time of the building permit. Subsequent applications for lot creation would be required to provide that engineered grading and drainage plan because it's closer to the intersection. If you look at the contours in the area, the drainage from that lot flows. It doesn't flow down Campbell Rock Road. It flows to the side over to Concession 20. And it flows into the parent, what would be the parent parcel. However, when we look at post-development drainage, the requirement is always that it meets pre-development levels. So they would be required to control the drainage on the property.
Councilor Colburn, did that answer your question at this time?
Well, sort of. I mean, thank you, Jen. I do understand that the engineered drainage plans protect that particular property owner. I don't think it necessarily addresses drainage issues that result to the rest of the community, but I will leave it at that for now. My second question and comment is absolutely not appropriate at this time, but I'm going to make it anyway, Mr. or Chair Burley. I don't wish to make, so this is the one, am I correct that we're rezoning it from agriculture to R1? Chair Burley and my colleagues on council, I feel like we keep chipping away and chipping away and chipping away at our agricultural lands. And I know it's just a bit here and a bit there, but it feels like death by 1,000 cuts. I think our council needs to have a discussion about how we value our farmland and make some policy decisions going forward. But for sure, with apologies, that's a discussion for another time. Thank you.
Good comments, Councillor Colburn, and look forward to the discussion. Madam Planner, please go ahead.
Thank you, Mr. Chair. Just as in response to Member Colburn's comments, that portion of the property that's being rezoned residential is within a settlement area, the secondary settlement of Kemble. It's not actually part of the agricultural designation under the county plan. So for settlement areas, that's where the province tells us that growth and development should occur. So it's within an area designated for development. We're not taking farmland away because that portion of the property is not within an area designated for farmland. Just as a point of clarification for everyone. Thank you.
Thank you, Madam Planner. Okay. Ron, please go ahead.
Yes, I shall be very brief on this one. Just Jennifer did a good job in explaining the proposal. Just a bit about the lot grading and drainage. By requiring the new owner, whoever buys the property, to hire an engineer and do the lot grading and drainage plan. At that point, you know specifically what development is proposed on the property. To do one before the deed is stamped would be just the general lot grading and drainage plan without any specific details. So it's kind of hard to do that. With regard to the lot grading and drainage, I'm sure everybody understands this. It's not a matter of just making sure that the water flows off your property in a manner that's acceptable to the owner of that subject property. You can't take it to the edge of your property and then I don't care where it goes from there. No engineer in the world is going to put their stamp on that. So the engineer has to make sure that not only the water flows off this severed lot, but it finds an outlet that does not impact on the neighbors. Thank you.
Good comments. Councilor Pringle, please go ahead.
No, actually, Ron just answered my question there, so I'm good.
Okay. Does the committee have any other questions? Seeing none, I'm going to read the recommendation. It has been demonstrated that application B1822 for Z. Taylor and T. Christie for lands described as concession 20 part lot 40 Campbell consistent with the provincial policy statement 2020, the County Gray official plan, recolor gray, the Township of Georgian Bluffs official plan, and the intent of the Township of Georgian Bluffs zoning bylaw 2020. It is recommended that the application be approved subject to the following conditions. 1, that a reference plan be completed and copied with the municipal clerk or an exemption from the registry plan be received from the land registry office. 2, that pursuant to section 5342 of the Planning Act, the certificate of consent be affixed to the deed within 2 years of giving us a notice of decision or as specified in the Planning Act at the time of deed stamping. Note, Section 5343 of the Planning Act requires that transactions approved by this consent must be carried out within 2 years of the issuance of certificate, that is stamping of the deed. 3, that the applicant pay the applicable consent certificate fee at the time of certification of the deeds. 4, that the applicant pay 5% cash in lieu of parkland in accordance with the Planning Act. 5, that a zoning bylaw amendment be enforced in effect. Someone to move to put on the floor, please. Moved by Deputy Mayor Carlton, second by Councillor Barfoot. Is there any discussion on the motion before us? Seeing none, I'll show of hands, all in favor. The motion is carried. I need a mover to adjourn the meeting, please. Moved by Councillor Pringle, second by Councillor Coburn. There's no discussion. The show of hands of adjournment. The motion is carried. Okay, we're down to our last minor variance. This is the meeting of the Committee of Adjustment to consider for consent for Sue Brown under Section 53 of the Planning Act regarding property located at 130 Crookshank Shell Lake. Madam Treasurer, please go ahead.
Thank you, Mr. Chair. There have been no requests for deferral or withdrawal of this application. Notice of this consent in accordance with Ontario Regulation 197/96 made under the Planning Act was given on July 19th, 2022 by ordinary mail to all property owners within 120 meters of the property which is subject to the application and to all the required agencies. Notice was also posted on the subject lands and the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the Committee. Only a person or public body that requests a notice of decision of the committee in respect to this proposed consent may submit an appeal. So this application proposes to separate two lots that merged when they were registered in the same name. So the area of the township, this is located in Shallow Lake, and there's a 23-acre severed lot, which is part of a wetland, and that is going to be donated to the Sydenham Conservation Foundation. The retained 10.5-acre lot will be rezoned to permit a dwelling to be built within a building envelope delineated by the environmental impact assessment that was conducted for this property. A portion of the lot will also be rezoned to environmental protection. The environmental impact study contained a remediation plan for the portion of the retained lot where the wetland was filled in a while ago. All development and maintenance requirements will be captured in a site plan agreement and registered on title to the lands. So the environmental impact study went and it looked at whether or not there was a developable parcel on the property. So in the front corner of the property, excuse me, I've abutting, I believe, Crookshank, there is a portion there that's been designated for a development envelope outside of the EP and outside of the wetland feature. The remainder of that property, the EIS has identified it needs to be remediated. So they're trying to get back to restore the wetland features. So through that, there is a required remediation and maintenance plan that would be captured within the site plan agreement. So this effectively would enhance the wetland feature and restore it, which is a really good thing. So this staff report does contain a review of all the applicable policies, which, provided mitigation measures are adhered to, do support the application. Provincial policy does permit partial services in settlement areas to allow for infill and minor rounding out of existing development, provided site conditions are suitable for the long-term provision of partial services with no negative impact. So there's a water main that runs along Division Street, and the operations department has confirmed that the service connection is available, and the applicant will be required to pay to connect to pay all the costs associated with that connection. There are no municipal sewers in Shallow Lake, so the site will be serviced with a septic system. The design of the system will be determined at the building permit stage and must comply with Ontario Building Code regulations. There is an associated zoning bylaw amendment application to facilitate this severance application, and it seeks to rezone the portion of lands that are zoned PD, plan development, to R1, and that's to allow that development envelope and residential development to occur. The application also seeks a 0-meter setback to the EP zone, and that's supported by the environmental impact study that was provided. And then it will also recognize the residential development envelope on the property. So I do note in the report, committee is aware that in the absence of a parkland cash in lieu policy, staff have been recommending that cash in lieu of parkland be paid for all applications. In previous applications, the committee has waived the requirement for cash in lieu where the lands are being donated for conservation purposes. So you will note that in this report, the recommended severance conditions do include the cash in lieu payment, and committee can direct staff to remove that as a condition of severance if you wish. The application was circulated to the Conservation Authority, and they have no objections to the approval of the subject zoning bylaw amendment and consent application. And they understand a site plan agreement will be implemented to address the natural heritage measures identified in the EIS. The County Planning Department provided positive comments are received from the Conservation Authority on the environmental impact study, and the mitigation measures are implemented. They have no concerns. They wish to be notified of any decision with the file. The Risk Management Office has no comments. And we did circulate this application to all property owners within 120 meters. And I received written comments from Tara Grady. And Ms. Grady noted concerns with noise, traffic, the destruction of the natural view, and a disruption of the peaceful enjoyment of our property, in addition to concerns related to the environment and the habitat that the property provides for animals. So in response to her concerns, I did provide her with a copy of the EIS, as well as the Conservation Authority comments on the application and the review of the review of that EIS. As clarification, there won't be tree removal from the building envelope as it's already been cleared, but there will be significant remediation of the property north of the development envelope as stated in that EIS. So the other thing to remember is that this is a residential area where the county and township official plans direct growth and development. The property is designated for residential development. No further correspondence was received in response to the information provided by planning staff. The report does recommend the application be approved with the conditions noted in the report, and I'd be happy to answer any questions.
Thank you, Madam Planner. Terry Ann and George Goody, register with the clerk to comment on the application. Terry Ann and George, with comments. Please state your name for the record.
Terry Ann Good. Okay, thank you, Chair Burley and committee, for allowing me to present our concerns with the proposed lot severance, rezoning, and development of the Plan 857, Lot 1551. In review of the environmental impact study that was completed May 31st to October 21st, 2020, for a total of 5 hours spent on property, we've noted a large selection of wildlife, including birds, mammals, reptiles, amphibians, and insects that were currently residing in this area and are not included in the study. Firstly, all of this wildlife has been noted habitating this general area and moving freely between the houses located in our area and the offset property in question. The following have been observed on numerous occasions: red fox, raccoons, mink, muskrat, rabbits, black squirrels, red squirrels, chipmunks, moles, and brown rats. The brown rats now in the conservation area. We're aware of 2 gray squirrels. The survey did cover gray squirrels, but they are no longer with us. Reptiles, brown garter snake, painted turtles, snapping turtles. These have been found on our properties and have been returned to the subject property for their safety. Amphibians, bullfrogs were both seen and heard, so we believe there are at least 2 on the subject property. According to the bullfrog survey, there have been none reported in the Shallow Lake area since 1989. Mentioned in the study was the northern leopard frog. In previous years, we've had a substantial presence on our property, but we've noted a large decline this year in the numbers of young sighted. Butterflies. Monarch butterflies are an endangered species. We've grown milkweed in our front flower bed and have pictures of monarch caterpillars on the milkweed, so we've seen them. Also have been sighted red admiral butterflies that have a lifespan of 3 weeks. Insects. We've got common honeybees and great eastern bumblebees. Both of these bees are seen on our property and on the subject property. Also witnessed as the transverse flower fly, it looks like a bee, giant water bug, and crane flies. Dragonflies, there are numerous varieties of dragonflies, present in significant numbers. Birds. And all these animals that I'm mentioning are not included on that survey, okay? Birds, Canada geese, chickadees, hummingbirds, evening grosbeaks, male and female. Grosbeaks are a declining species currently uncommon in the eastern United States. Cowbirds, kingbirds, northern flicker, downy woodpeckers, wild turkeys, ruffed grouse, indigo bunting, pileated woodpeckers, and red-bellied woodpeckers. We have a picture of either it's an immature great horned owl or a northern screech owl. Both of these species have yellow eyes and ear tufts, so we're not sure which one it is. Red-tailed hawk. That's being the most common hawk in Ontario. Mourning doves, turkey vultures, and crows. Located just east of the property in question, we have witnessed a pair of trumpeter swans, which is a species of great concern, and I've reported this with pictures to the Trumpeter Swan Society for their information and recording. Also noted on the subject property is a huge selection of terricola. It's a purple flower that is preferred food for the yellow-banded bumblebee, which is a species at risk. We've noted that the common honeybees also seem to prefer this food source. We've attempted to grow this on our own property, but the main food source in this area is located on the subject property. Given the ongoing decline in the honeybee population, having a food source that is not contaminated with pesticides or herbicides is critical to maintaining a healthy population in a species under stress with colony collapse. The above listed 38 species of wildlife, of which we have significant photographic evidence, is just what we've been able to identify and are not included in the environmental impact study, which includes 23 species in total. Our concern is what else could be currently residing on this property that we are not aware of and would be a species that could be at risk or endangered. Has there been an eDNA study, that's an environmental DNA study, completed, or trail cameras placed on the property to better monitor the wildlife residing there? At least then we would know what we're dealing with, because I don't think we are right now. We'd like to see more clarity as to exactly what residence is being considered for this property according to the environmental study, and have reviewed the severance application, which states a single family home or residential. But the amendment on the zoning bylaw, and I know this isn't the zoning meeting, but it links in. Zoning bylaw shows the proposed building structure as unknown at this time, and also talks to establish a residential environment development envelope. So I have a better understanding of what that is now, because that's as to the ESA. So I'm assuming the creek, which has the setback and all the rest of it, is now outside of this envelope. So there's there's 10 and a half acres that we're talking about. And I'm sure you can all appreciate that last thing we want to do is wake up some morning and they're building a row of townhouses on this property. If the request for the lot severance change is approved by the council, we would respectfully ask if the frontage ditch along Crookshank Street be included in the section of property to be donated to the Sydenham Foundation, as this ditch, especially in the spring, drains into the creek, and this area should be included with a setback similar to the setback recommended in the environmental study for the creek running across the back of the property. This creek is also where all of our properties drain. All our properties across here, all the eaves troughs go underground and go out to the ditch, and they all link and go across to that ditch. So if that gets plugged up, that's all going to back up, and then we're going to have problems on our side of the road. Also of concern, sorry, I lost my place here. This would allow the frontage on Crookshank Street to remain pristine. Also of concern in the zoning bylaw amendment, they've asked to have the creek setback reduced. Given the request for the reduction of the creek setback and the zoning bylaw types of servicing, the sewage is denoted as septic tank and tile field. The close proximity of the creek could be impacted by effluent runoff. So I hope that the septic system would not be considered appropriate and a holding tank would be recommended. And also with all this rubble that's been dumped on this property over time, I'm sure that trying to put in a tile bed, you're not going to have good drainage. I can't imagine it. It's supposed to be 2 meters deep, so we're talking 7 feet. And even if they put it on top, it's still not going to drain properly. So I think we're going to see a lot of concern with the creek. And that's where that runs down into where a lot of your Canadian geese have their babies every spring along that river. We've reviewed all the documents available, but really are unsure to exactly what is planned for the development of the property and are looking for some reassurance that this area will not be overdeveloped now or in the future. I do have a quote. If the bee disappeared off the surface of the globe, then man would have only 4 years of life left. No more bees, no more pollination, no more plants, no more animals, no more man. That's from Albert Einstein. So thank you very much for allowing us the opportunity to present our concerns.
Thank you very much. Comments?
Yeah, I'd just like to echo a couple of things my wife said. The ditch that's along Crookshank is, I think, the most sensitive part, at least for the surrounding neighbors. The first year we were there in the wintertime, we had quite a lot of water that had to drain because we had a lot of snowfall. And if that ditch goes away, that would be a big problem. I don't have the records. We've only been there 5 years, but I've been told by at least one of my neighbors that that road's been raised twice because of drainage concerns. Also, too, I feel that this is going to completely change the character of the neighborhood. So whatever development ends up getting approved, it would be nice if it's would keep the character intact, more or less. Division Street is actually quite level. I believe the water line runs down there. If all the entrances for any planning was there, that would be a much minimal impact. But if there's any real development on the Crookshank side, that's going to cause problems in the future, in my humble opinion. Also, too, the Terracola just happens to be on the roadside in the property in question, and there is Terracola all around Georgian Bluffs. I've seen it, yes. However, what you normally see is chicory and Queen Anne's lace. That's pretty well it. So I looked at the application as it stands, and I thought the proposed use of property was a little on the vague side, and I would just appreciate if it would be reviewed fully and our concerns will be looked after. And thank you very much for taking the time.
When I lost my spot, when I lost my spot, I forgot with the Terracola, it's a preferred food for the yellow-banded bumblebee, which is a species at risk. And we've been keeping our eyes open for it, looking for it. I think I saw one maybe, but that's their preferred species, and or their preferred food. So, and a lot of the other bees seem to like it as well, and it's prolific along that side of the road. So again, it just goes to that keeping that ditch the way it is, because it's very important for what we need to survive. Okay, thank you.
Oh, just one more little thing. Sorry. I've got extensive photographs of a lot of those things. If I could leave them somewhere, you guys are quite welcome to take a look at them. And I know you're busy, and taking a drive out to that lot was a lot, but we just feel it's definitely worth review.
Thank you for your great comments. And maybe if you have anything at all, the photos, give them to the clerk. And I wonder, could we have a copy of your comments to the clerk, please? Okay. Sue Brown, register with the clerk to comment on the application. Sue, please go ahead.
Can I be heard right now?
Yes, we can.
Okay. Our idea was to donate the parcel to Sydenham Conservation Foundation because we feel they can best represent the interests of that property to protect exactly what the neighbors have spoke about. I lived actually for quite a few years on the other side of where those neighbors live now, presently. I've owned this property twice. I treasure it. I enjoy it. The big thing is I'd like the Conservation Authority to look after the 23 acres. The 10 acres we'd like to retain. The building envelope, and Jen can explain better, is in the west corner Our idea would not be to touch Crookshank Street. The entrance would be on Division Street because we too appreciate any of the natural habitat along that area, as well as the same with the trees that are presently there. It wouldn't be clear cut it. Those trees would maintain around the perimeter of that property. We're talking a corner of a 10-acre parcel. And it's a single family home. It isn't a triplex, it isn't an apartment building. It's a single family home, and it would be as tastefully done and constructed and in appearance, in curb appeal, as any of the neighboring properties.
Thank you, Sue.
You're welcome, Dwight.
Any comments from our planners? Jen, please go ahead.
Thank you, Mr. Chair. So just related to the concerns with the ditches and the water flow, ditches in the township of Georgian Bluffs are part of the road allowance, so they are maintained by the township. They're not part of private property. If there is any, the air photos that I've seen do show some water movement through the property, but that's part of the wetland feature. There's no intent of any development on this parcel. It's not intended to negatively impact the wetland feature or impact the neighbor's drainage. I would note that, as Sue mentioned, while the retained parcel is 10.5 acres, the actual development envelope is really 20 meters deep, which is 66 feet, as well as approximately 200 feet along Division Street. So 68 meters. What you have to remember with that is there are setbacks. So there is a front yard setback from Division Street, and there's also an exterior side yard setback from Crookshank. So I believe that's 6 or 7 meters in. So now with those setbacks from the front and side yards, there is a decrease in the size of the developable area. Any other part of that property north of the development envelope has been identified on the EIS as requiring remediation, and it's not intended for any sort of residential development. And as Sue mentioned, I mean, realistically, the lot could only support a small detached dwelling in order to accommodate the septic and the house and the driveway within that development envelope, because it doesn't, the development envelope restriction requires that everything related to the residential development be within that envelope. So when you look at a septic system, the building code has required setbacks. So it's no part of any septic system can be located within 10 feet of a property line. So that's another constraint within that development envelope. And just in terms of the servicing for the property, given that it's such a small development envelope, the likelihood of a tertiary system, which is monitored, would be likely in that area. I do know from my discussions with the building department that a holding tank for a residential house is not up to code. So they wouldn't be able to have a holding tank on that property. If they couldn't service it with a septic system, either the class 4 or the tertiary system, they wouldn't be issued a building permit, as it would not comply with code.
Thank you, Madam Planner. Does the committee have any questions? Deputy Mayor Carlton, go ahead.
So when you comment about the building envelope, I'm noting that they are asking for the setback to be reduced from 15 meters to 0 on that EP zone.
Madam Planner?
Thank you, Mr. Chair, through you to Member Carlton. So the EP zone is north of the development envelope. So the environmental impact study determined that that setback that we typically have in the zoning bylaw isn't necessary because of the remediation and the features that are physically present on the property. So developing with a 0 meter to that EP zone wouldn't have a negative impact on the wetland feature or the EP zone and the features there.
Okay, thank you. Sorry. Grant, please go ahead. It's been a long day.
Yeah. Thank you, Mary. Yeah, so I just wanted to say thanks to everybody that spoke here. There was some great information that came from all this, but for me and for the planner here, on the picture that shows in the diagram, that triangle dotted line, that's basically where the building lot would be allowed on this property.
That's correct.
So virtually, and it is going to be a laneway onto Division Street, so they won't be able to come out onto Crookshank, and it's virtually right at the edge of town, not set back into the bush anywhere away. So from what I see with the donation of the land to the conservation and the envelope that they have, they're really not going to disrupt too much land in that area with a single dwelling. So it's almost in the almost ideal spot if you're going to put a place, because it's going to be less disruptive there than if they tried to put it anywhere else. So I know it's hard to be an advocate for both sides, but in this instance, I think both sides have really done their homework, and to me, it looks like the perfect location for that spot in that envelope that's there. So that's all I want to comment.
Thank you, Councillor Pringle. Councillor Colburn, please go ahead.
Thank you, Chair Burley. With your permission, I'd like to go back to Member Carlton's comment, and with apologies to our senior planner, I'm not sure that I understand the explanation. So we see setbacks established from environmental protection zones for a reason. It's there to create a buffer, and I'm failing to understand why then, if we have these buffer zones and these setbacks, why in this case is it okay to say we don't need a setback? Essentially, I mean, we can say we're moving from 15 to 0 meters, but really what we're saying is that we don't need a setback. I wonder if I could get another explanation as to why that's okay here.
Certainly, Madam Planner, you comment?
Thank you, Mr. Chair, through you to Member Coburn. So with our zoning bylaw, we have a 15-meter no development setback applied to all development from that EP zone. What's happened in this situation is, and that's just a general development guideline. So if you're 15 meters away from that zone, then it's determined that you're developing outside of any natural features or hazards. With this situation, what happened with the environmental impact study is the applicant hired an environmental consultant who worked with the Conservation Authority to determine a terms of reference for the study. So they looked at what this study needed to address and to determine whether or not that portion could be developed. And that terms of reference also includes provincial requirements. So if you read through the EIS, it'll and you speak to the environmental consultants, they tell you the province directs them. They'll say within this provincially significant wetland, these are the things that you need to assess, and this is the sort of study that you need to do. So it will determine whether or not you need to do a nighttime study to determine like the breeding or the habitat of bats, or if you need to go in and look at the turtles or any sort of amphibians that would be typically present within that provincially significant wetland. And so from that, because the consultant was on the ground and doing an actual assessment of the features, in his opinion, he determined that building within that development envelope in that area would not negatively impact the natural heritage and hazard features on the property. So his recommendation in the report was that that 15-meter setback from the mapped environmental protection zone wasn't necessary because where development was occurring wasn't going to impact any features. So there's a difference here where if you do an on-site evaluation of the physical features of a property, it's different than looking at a zoning map and saying, here's where the boundary of the green line is. As a general rule of thumb, you have to be 15 meters away from that. So because we've actually had an on-site and the Conservation Authority has reviewed the EIS and they've been to the property on different occasions, then that's how you justify that 15-meter stated setback within the zoning bylaw can be reduced to 0.
Does that answer your question, Councillor Coburn?
It does. And thank you, Jen. I'm going to try really hard to remember that explanation for next time, but no guarantees. That for sure does explain it better to me. With your permission, Chair Burley, the only other comment that our presenters brought forward that I'm not sure has been addressed is the impact on the creek. So I wonder if our planner could perhaps respond to that particular concern expressed by the two presenters here tonight.
Madam Planner, are you able to comment?
Could I ask the neighbors to repeat their comment about the creek, please?
Certainly. Gary, go ahead.
Okay, the situation we have is there's a bridge just I guess that's east of us where the swamp drains into the creek that ends up going through the center of Shell Lake. And the ditch that is actually off of Crookshank looks like a dug ditch. Yes, it's probably on the road allowance. My big concern was having entrances over it, which obviously by this sound is no longer a concern. The creek issue is it's a creek that is not really fast enough or big enough for ducks or geese or things like that, but it's big enough for the little guys, the frogs, the water beetles and things like that. It never dries, so it's not really just a spring or seasonal creek. There's always usually water in it. And it is our drainage for the spring runoff because I don't know where you guys live, but Shallow Lake, if they say 6 inches of snow anywhere else in the world, we get to 12 every time. It's just the way it works. So more or less, if there's no real impact on this creek, then there would be actually nothing to object to simply because that was the big thing. Because unfortunately, if you put entrances over it and put culverts over it, it just changes water flow. I lived in a property in Mayford my parents owned. I remember it being 20 feet across with water one spring because the ice jammed up the little culvert they had. And then they replaced it and put a big 6-footer in and it never happened again. So yeah, I mean, the best planning can be wrong. But as it works right now, I've only got 5 years experience there, but everything has been so far so good. So with no change to that situation, I would say I can't see anything to object to, and I hope that would answer Councillor Coburn's question.
The only other thing I think we talked about was the concern with the septic system and the tile bed. And again, because it is wetland, I guess I'm just trying to visualize how we can build a system that's going to be safe and not end up in the creek and contaminating it. I don't have the picture in front of me, so I don't know where the house is planned.
Oh.
But I am looking over your shoulder, by the way.
Madam Planner, go ahead.
Mr. Chair, if you don't mind, I'll show the neighbors the location. And that's going to be remediated.
So this will be like that, that's a good thing. There's no 2 ways around. That's a good. But I guess my concern is because creek, you can see there's the ditch here and it runs into the creek. How can we put a tile bed in there that's going to be safe?
Yes. So, Mr. Chair,
Go ahead.
through you to the committee, So we're referencing figure 9, which is the natural heritage buffer zones and development envelope that's provided in the EIS. It's also attached to the report package. That blue line is not a creek. It is actually the boundary for the provincially significant wetland. Is what the neighbor's referring to. So that's the PSW boundary.
Okay.
Is delineated by the province, the MNRF mapping, and it runs parallel to Division Street, and it tucks in behind the proposed development envelope on figure 9.
But then the creek is just up here.
And so I'm sorry, I forgot. Terry is just pointing to an area outside of where the proposed development is, and that's the creek.
Because it goes up and goes around here and it goes underneath the road.
Okay, so the creek appears to. Where's my? The creek appears to run, I guess, northwest of the development envelope and up and around into the wetland, outside of the development envelope or even the remediation area here that's planned for the property.
Okay, Council Colburn, being virtual, or do you understand what we're talking about? Okay, good.
Thank you.
Thank you, Mr. Chair.
Does the committee have any other questions? And I must say thank you very much for a great presentation. Really appreciate it. Thank you. I'm going to read the recommendation. It has been demonstrated that the proposed application is consistent with the provincial policy statement 2020.
Excuse me, Mr. Chair, if I could interrupt. Member Barfoot has her hand up.
Sorry, Carol. Please go ahead.
Thank you, Mr. Mayor. I just had to get my 2 cents worth in. Being a member of the Sydenham Conservation Foundation, I'm going to speak up to all the good work they do. I'm not sure if a lot of people know that they now are responsible for the lake, for the shallow lake itself. They've worked tirelessly to try and keep that a pristine, how can I say, waterway. But they do a lot of good, and I know when they monitored the river or stream that goes through the village of Shallow Lake by the store, it got a lot of information. And I think we are very fortunate to have a group, local group such as them, that want to step up and monitor the situation. Anyways, that's all I have to say. I just hats off to the Sydenham Conservation Foundation for all the good work that they do.
Thank you, Councilor Barfoot. Excellent comments. So there's no other questions from the committee. I will read this motion. It has been demonstrated that the proposed application is consistent with the provincial policy statement 2020, the County of Grey official plan, the Township of Georgian Bluffs official plan, and the Township of Georgian Bluffs zoning bylaw 2020. It is recommended that severance application B1922 for Sue Brown be approved subject to the following conditions. 1, the reference plan be completed and a copy filed with the municipal clerk, or an exemption from the reference plan be received from the Land Registry Office. 2, the pertinent to Section 5342 of the Planning Act, the certificate of consent be affixed to the deed within 2 years of giving of the notice of decision or specified in the Planning Act at the time of deed stamping. Note, Section 5343 of the Planning Act requires that transaction approved by this consent must be carried out within 2 years of the issuance of certificate, that is, stamping of the deed. 3, that the applicant pay the applicable consent certification fee at the time of certification of the deeds. 4, that the applicant pays 5% cash in lieu of parkland in accordance with the Planning Act. 5, that the applicant enter into a site plan agreement with the township to address the mitigation measures identified in the environmental impact study, AWS Environmental Consulting dated February 2022. And 6, that a zoning bylaw amendment be enforced in effect. Now, Madam, excuse me, Madam Planner, you referred to the 5% in lieu of parkland dedication. And I think you indicated that if we did not want to, since the land's being donated, if we wanted to waive that condition, we could?
That's correct, Mr. Chair. You can direct staff to remove condition 4.
Yeah, I'm going to ask the committee, Deputy Mayor Carlin.
I would make that motion that we waive that section of it.
Madam Clerk, just direction good enough, or do you want a separate motion?
To amend the motion to remove.
So we'll
condition
vote on the
4.
amendment first?
Yes.
Okay, and it's seconded by Councilor Pringle. The amendment is to waive the 5% in lieu of parkland dedication. So show of hands, all in favor of the amendment? The amendment is carried. Thank you. Now we're going to vote on the main motion. I'm sorry, Madam Clerk, did I get a mover or seconder? I don't think I did I? No. I need someone to move the main motion. Moved by Councilor Colburn, second by Councilor Barfoot. Is there any discussion on the motion before us? See none, the show of hands, all in favor? The motion is carried. I'll now ask for a mover for adjournment, please. Moved by Councilor Pringle, second by Councilor Barfoot. There's no discussion, the show of hands, all in favor of adjournment? We're adjourned. Thank you. That's all our public meetings here tonight, so I'm going to move down to unfinished business. And it's for recommendation report for Edburn, B1121, B1221, B1321, and Z1721. Thank you very much. And Madam Planner, you can take this on?
Thank you, Mr. Chair. So this is a recommendation report coming back before the committee for consideration. In February, on February 15th of this year, there was a committee of adjustment meeting to consider three severance applications, B11, 12, and 13 of 2021. Those applications proposed to create 3 lots along Maple Ridge Road. The proposed lot sizes do meet the minimum lot area and frontage for partially serviced lots in the R1 general residential zone. In accordance with the environmental impact study, the environmental protection zone boundary will be realigned, and relief to the zoning bylaw would be necessary to permit a 0 meter setback to that realigned EP zone. The lands within the Niagara Escarpment Plan area will remain zoned NEC. In no part of the proposed lot creation is within the lands that are zoned NEC, Niagara Escarpment Commission. So when the committee considered the applications at the February 15th Committee of Adjustment meeting, we received comments from Saugeen Ojibwe Nation, that they wanted to see an archaeological assessment, and so the decision on the applications was deferred. Additionally, we received comments from a number of neighbors in the area who expressed concerns with servicing and stormwater management. So to support the applications, the applicant has provided a number of reports and studies, including a planning justification report, stormwater management report, grading plan and site plan, a nitrate study, and environmental impact study. In response to the comments that we received at that February meeting, the applicant then, following the deferral of the applications, went and had an archaeological assessment done. and provided an addendum nitrate study by Peter McCallum in Consulting Engineers, and also had his engineers provide responses to comments that were raised by the residents in the area related to servicing and stormwater as well. And then additionally, the applicant's agent, Ron Davidson, did provide post-public meeting summary comments. So initially, there was a policy review provided with the application in February, and all comments that we received prior to the submission of that report were presented to the Committee of Adjustment at that February 15th hearing. The comments are appended to this report package for your review and consideration. And additionally, not included in that report were comments from the City of Owen Sound that were submitted after the report submission deadline, but and they are included in the in this report package. And there was a number of neighbors who made oral presentations at the public hearing, as well as members of the development team. Recordings of the meeting, the one on the 15th, which was the Committee of Adjustment to consider the severances, as well as the Committee of the Whole meeting on the 16th to consider the zoning, are both available on the township's YouTube site. We received additional comments after the meetings from neighbors to the proposed development, the Kaufmans. So they submitted additional comments on June 1st, 2022, as well as on August 15th, 2022. So those comments are appended in their entirety in the package for the committee's consideration. So the report that you have before you this evening is a report that considers the concerns raised and provides some information on how the applicant has addressed those concerns. So an archaeological assessment at the time of the public meetings to consider the applications, as I noted, Saugeen Ojibwe Nation requested an archaeological assessment to determine if there were any areas of significance on the property. An archaeological assessment was conducted by Amit Consultants Limited with representation from SON on the property on June 22nd, 2022. And so as you note in this report, the archaeological assessment noted that as a result of the property assessment of the study area, physical evidence of human activity in the past was observed, but is too recent to qualify as an archaeological resource and is of no cultural heritage value or interest. Accordingly, no archaeological resources were documented. They conclude that no further archaeological assessment of the study area is warranted, and that provincial interest in archaeological resources with respect to the proposed undertaking has been addressed. The proposed undertaking is clear of any archaeological concern. So I reached out to SON for some follow-up comments. I didn't receive any from their office. However, I do have email correspondence indicating that they participated in the terms of reference for this archaeological assessment, as well as they had members of SON on site while the assessment was conducted, and an email noting that there was no further concerns with the assessment was also provided. The next issue raised by through the process was by the neighbors. So there are a number of residents in that subdivision that are concerned with water servicing. So specifically and primarily the pressure for residential use and for firefighting purposes. Residents noted that the hydrant in the neighborhood is painted black and is not available due to lack of water pressure. So we reached out to AQUA, the Ontario Clean Water Association, to clarify for us whether or not the water pressure and volume concerns raised by the neighbors are going to be impacted by an additional 4 homes on the property. And they They noted that the pressure valve could be adjusted so existing homes do not experience a change in pressure. Further to that, GSS Engineering is providing a master servicing study for the township. So they have done assessments in this area of the water supply and the water volume. And they did provide us with comments. They noted there's currently 21 water connections on Maple Ridge Road. With the 4 new houses, that would be 25. They did an estimate of the average daily usage, and excuse me, they note that minor increases in frictional pressure losses should not noticeably change water pressure at the existing homes. 4 new single detached homes will not increase the required fire flows in the area and therefore will not worsen the issue of inadequate fire protection. So there's a trigger for the number of the density of development. So with the addition of 4 new homes, it doesn't trigger a requirement for an increase in the required fire flows. So it's not making the situation that's there any worse. The amount of fire flow remains the same for the homes, whether those 4 homes are there or not. The reason why the fire protection in that area is inadequate is because of the size of the water main. It's undersized and it just doesn't have, it cannot provide the minimum fire flows of 3,000 liters per minute because of the size of that water main. They do have a recommendation to improve fire flows. I've included that comment for the committee's consideration as well as for council's consideration tomorrow. That would be part of that master servicing study, and recommendations from that will be presented to council for and action items will be identified once the study is complete. The nitrate study, so Peter McCallum conducted an additional nitrate study in response to the concerns raised by the neighbors. So all the comments that were received through that circulation process from the neighbors were forwarded to the company for response. And they did conduct a study in accordance with Ontario Ministry of Environment and Energy guidelines. So the D54 Individual On-Site Sewage Systems Water Quality Risk Impact Assessment. And the results of the second analysis indicate that the proposed building lots with on-site sewage disposal systems can accommodate adequate dilution of nitrate loading below or equal to 10 milligrams per liter in the leaching beds of the proposed septic systems. So that is the provincial requirement. 10 is the threshold. So I also spoke with our chief building official, and I provided him with comments that were submitted by the residents for response. So when the building department receives an application for a permit, they also, for a building permit for a dwelling, they also assess whether or not the proposed septic system is adequate for the to service that house that's being proposed. They work under the requirements of the Ontario Building Code, and permits are issued based on what those requirements are. So if you go and look through the code, you'll see that there's also a section in there that provides for the operation and maintenance of septic systems as well. So it's not just a matter of getting a permit, putting your septic system in, and that's it. You're required to maintain those septic systems in accordance with the code. So the chief building official, Tim Lewis, provided a comment noting the Georgian Bluffs Building Department assesses septic applications and soil conditions at the time lots are developed. Tertiary systems have all different levels of effectiveness, and many factors weigh into approving a system. The goal with most tertiary systems should be to produce effluent similar in quality to pool water. Soil conditions depend on the install and may or may not be a factor. So his examples were raised beds, compacted soil, size of the contact area. So he noted that it's not the building department's role to do comparisons, compare a tertiary system to a class 4 system. They assess what's being proposed and ensure that regulated distances and construction requirements are adhered to for a particular site. The maintenance, servicing, and monitoring alarms and checks for tertiary systems are legislated. And so those are found in the building code. In his experience, since tertiary systems are monitored and alarmed, they are less likely to be a concern. Installed tertiary systems must be equipped to reduce or eliminate nitrates to acceptable levels. Building code does not require a nitrate loading review. However, where there is a concern, it can be better monitored with tertiary systems, as you can take a sample before the clean water enters the distribution system and make it a part of an annual maintenance program. So there are systems such as EcoFlow that remove or reduce nitrates very effectively. So the addendum report that Peter McCallum provided does support that lots can be serviced with class 4 septic systems consisting of a holding tank and a leaching bed, similar to what already exists in that neighborhood. As noted by the CBO, septic applications and soil conditions are assessed at the time of the building permit application. So permits would only be issued if the application conforms to the Ontario Building Code requirements. And so when the chief building official and the deputy chief building official review those septic applications, they also have the discretion, to require a tertiary system if that's what's deemed necessary by the results of the septic design. In terms of stormwater management, stormwater management plan was submitted by Daryl M. Robbins Consulting in support of the application. Within that stormwater management plan, it does note that it considers the mitigation measures outlined in the environmental impact study. It incorporates a hydrogeological assessment completed by Peter McCallum, and it meets the specifications of the MOE's Stormwater Management Planning and Design Manual. So this stormwater management plan has been designed incorporating the environmental impact study, as well as the provincial requirements for stormwater planning and design put out by the province. The stormwater report concludes the post-development flows have been controlled to pre-development levels with the use of grass swales. So within that report, the engineer did identify there is less than 2 hectares of developable land. And so that's insufficient space to accommodate a stormwater management pond on site, which is why the application proposes grass swales. The grass swales that would be proposed within the township's road allowance are intended to achieve quantity and quality controls in the absence of a stormwater management pond. So that's what the Conservation Authority has directed the engineer to design a plan that looks at post-development flows, not being greater than the pre-development levels. The swales, and I've went and included some additional reading information for the committee's consideration. The swales would be within the road allowance and maintained by the township, and that's similar to open ditches. If you look at other developments in the township, for example, Kilsyth, the stormwater management pond that was proposed to support the development in those 33 lots, that is owned by the township. So we have assumed responsibility for that stormwater management pond in order to allow the development to proceed. So swales on a road allowance are similar to ditches, except for the fact that the swales are intended to not only convey the water, but to treat it so that there's less sediment moving into the larger water features in the area. I will note that the maintenance of any swale or drainage feature on private property is the sole responsibility of individual property owners. The township, it does not maintain swales or drainage features on private property. The Stormwater Management Plan and Report was accepted by Township Operations staff and the Grey Sauble Conservation Authority. And staff recommend that the site plan agreement that's required as part of these applications and the environmental impact study address the installation of the grassed swale at the expense of the developer and require that it be installed prior to the commencement of development on the lots, just to ensure that the drainage system in place is in effect before the development begins on the lots. The site plan agreement will also specify that swales and drainage features on private property are the responsibility of the property owner and must be maintained in accordance with the approved stormwater management plan and report that support these applications. The other issue, I believe it's the last one, is the environmental impact. So we heard from a number of residents, they were concerned about the impact that the creation of the 3 lots and the development of 4 homes would have within that area. So the environmental impact report concludes that with identified mitigative measures implemented through site plan control, the ecological functioning, role, and natural heritage features will be maintained. So the special environmental features on that property, as long as those mitigation measures are adhered to, will not be, excuse me, will not be negatively impacted. The site stormwater management plan and the building envelopes were designed to implement the recommendations of the EIS. So when they did the environmental impact study, that study informed where the development envelopes could be located and what the appropriate setbacks were from any of those environmental features. And the environmental impact study was reviewed and accepted by the Grey Sauble Conservation Authority. So the site plan agreement will incorporate the mitigation measures of the EIS, and the agreement will be registered on the property, on the lands, and then registered on each lot once those lots are created. And then it runs with the land. So subsequent property owners know that there's a development envelope and that there is and there are areas on the property that are not to be altered or cleared. The staff recommend that the site plan agreement contain a provision requiring that each offer of purchase and sale provide a notification that development on the property is subject to the mitigation measures of the EIS and that tree clearing outside of the development envelope is prohibited. What we've seen with some developments in the township is that the property is purchased and nobody reads the development agreement. So with this requirement that that with every offer of purchase and sale, every time that property is sold, there will be a notification that comes right up front identifying that, hey, you need to read that development agreement, and there are restrictions for any sort of alteration on this property and development. And then that way we can ensure that the mitigation measures in the EIS are upheld as intended. So just in conclusion, the recommendation is to approve the applications subject to the conditions that are noted in the report. The conditions that are in the report are the same for each property that is proposed to be created. And I would be happy to answer any question that the committee may have. This is not a public hearing. This is a presentation of a recommendation report.
Thank you, Madam Planner. Madam Clerk, point of clarification. We will not be passing a motion here tonight.
Mr. Chair, I have made a recommendation that the committee approve the applications subject to the conditions that are noted in the report.
So the committee will need a mover and seconder to put it on the floor, and then we'll have a discussion on it. Okay. Your recommendation is very simply to approve the application? Is that what you're saying? I'm sorry, I don't have anything in front of me. That's what I'm asking.
Oh, yeah, so you should have the decisions or, yeah, so there, the recommendation is to approve all 3 applications.
Okay.
Based on the conditions that are in the report.
Okay. So I guess I need someone to move to put on the floor, please. Moved by Deputy Mayor Carlton, second by Councilor Pringle. Now, I'll open the floor up for questions from the committee. Councilor Pringle?
Thank you, Mr. Mayor there. Yeah, so I still got, even from the last meeting that we had here, so I got a lot of concerns over the request for this, especially the 3 lots out on the main road. I don't understand how 3 lots there are going to be compelling or fit into the neighborhood that's there. I think that those 3 lots are very aggressive to be put on that property that close together in that subdivision. That is one concern that I have. My other concern is the water runoff from behind those. If you put 3 properties there, you're going to have water runoff from the west side heading down through those ditches. So you're going to have accumulation of water in different areas now. That's another concern that I still have. When I walked the property back in the spring and April, the 3rd lot has a sinkhole on it that literally has water running 1.5 feet below ground level. I have a concern about that piece there, where that water will go. I've got concerns still over the nitrate levels there. There's numerous ones that failed in that report. It obviously got a passing grade, but there was numerous tests that failed on both the first and the second report. Those are still concerns for me. And really, for me, at the end of the day, it's just the density of 3 lots that close together on that property. I really have a hard time trying to think that that's a good idea for that particular neighborhood. I'd love to have the answers, I guess, laid out a lot better, but at the end of the day, I can't bring myself to see that that is a good idea for that particular property. I've never really said too much or turned down too much, but I've walked that property. I've seen that property. I've seen the houses out there. I just don't know how those 3 particular properties, those especially 2 and 3 that close together, are going to help out that neighborhood or make that neighborhood keep the values that are there with the size of the properties that are there. Those are just some of the concerns that I have.
Okay, well noted. Other comments from the committee? No comments from anybody? Yeah, Councilor Coburn, go ahead.
Thank you, Chair Burley. I mean, I would echo Councillor Pringle's comments. I think our planner has done a good job answering some of the concerns that came forward before. It's hard when you hear one of your colleagues say that he, witnessed the runoff and the water, and I'm just trying to get my head wrapped around what the reassurances are in the report versus what the realities sometimes are in the community itself. I don't want us to rush into this decision, and I guess I'm talking just to give folks a little more time to think about it, and hopefully there'll be a little more dialogue. I'm still conflicted about this one.
Thank you for your comments. My comments very simply is that we as a committee or even a council base our decision on information provided to us. We've had many experts that commented on this application, and they're all saying that everything's fine and hunky-dory, go ahead. But Councilor Pringle, you make some real good points. I just don't know if you can say that I feel 100% happy with 3 lots that close. We've been addressed the drains, we've addressed the septic, we've addressed everything, but it's still a real concern. We're basing our decisions on the information that's provided to us as a committee. That's what we're basing our decisions on. And we've nothing else to go by. Yes, Councilor Pringle, you did walk the property and so on in the spring. I didn't. You did. I respect your comments and so on, but we have to base decisions on what information is provided to the committee. That's the, and do I have concerns with it? Yes. Maybe 2 lots instead of 3. I don't know. It's just a comment that we as a committee need to base a decision on something. That's all I'm trying to say. Councilor Coburn.
Thank you, Chair Burley. I'm not sure that this is a fair question for our planner. Apologies if it's not. I used the expression earlier in this meeting, once bitten, twice shy. How is this situation, the guarantees, the additional asks or requirements, how is this situation different from the Campbell situation? And I don't mean to put you on the spot, Jen. And if I'm trying to compare apples to oranges, please say so. But I'm looking for some reassurance that we won't be dealing with another Campbell situation down the road. Thank you.
Madam Planner, do you care to comment?
Thank you, Mr. Chair. I would just note that Kimball has had historically, drainage problems for a long time. So we have residents there that have been monitoring the situation for 20 years. Township hasn't received complaints about drainage in this area. One of the things that I would note further to member Pringle's comments, the proposed lots are the same size, if not larger, than some of the existing lots. So with a lot on partial services, I'm sorry, I've just gapped on the minimum lot size for it. But the proposal exceeds the minimum lot size for a partially serviced lot. So I can see the properties in the area are they're about half an acre each, and that's what these 3 lots, except for lot. I'm not sure which lot number that is, but application B11 is 5,000 square meters. So 1 acre is about 4,000 square meters. So one of these lots is larger than an acre, which would make it double the size of all of the lots within the Maple Ridge Crescent. So the drainage issues in the area, because those lots are larger and the drainage is proposed to be controlled on site, it does make it a different situation than the Kimball situation. There are different factors that impact development in Kimball that aren't specific to this site, and that's something that we need to take into consideration. Additionally, there were works that were required to be done in Kimball that weren't necessarily completed prior to development occurring. So that's why within this site plan agreement, the swales would be required to be implemented prior to any construction activity occurring on the property. So the sites will be prepared to the fullest extent possible prior to construction occurring to build the homes.
Madam Planner, would it be a fair comment to say that this particular development has an outlet for water to go to, whereas versus Campbell, we're having problems with finding good outlets?
Through you, Mr. Chair, to the committee, I can't answer that. I don't have enough information on the drainage outlets in Campbell, and I would defer to the engineers to answer that.
Okay. Councillor Pringle, please go ahead.
Thank you, Mr. Mayor. Yeah, it's not that, not at the end of the day that I'm opposed to developing the area. I really struggle with it. I guess I'm going by what I see in the picture and how it's laid out. It seems very aggressive to put 3 lots. It looks close together when you see the drawings in that particular area. I guess that's what I see. I'm not opposed to the development, being in that envelope on there. I'm just not sure that I'm real happy with 3. So I guess, and my other question maybe on that is too, is I know that they have the 4th lot, which is the existing footprint that's there. How come it's not being, like, to me, that one should be one that should be developed? It's already there, as opposed to 3 new lots being created. What is there, can somebody like just explain why we haven't rebuilt back where the existing place was?
Madam Planner, do you care to comment?
Thank you, Mr. Chair. Through you to Member Pringle. There is intent to develop that that retained portion that lies within township zoning. So within the proposed stormwater plan, there is a delineated development envelope for that parcel.
Councillor Coburn, please go ahead.
Thank you, Chair Burley. I wonder if we should give Councillor Pringle a chance to follow up on that explanation if he wishes to do so.
No, I was looking for an answer whether it was going to be developed, and it sounds like it will be at some point in time.
Okay, thank you. So it seems as though I can only speak for myself because of the other issues we've had within our municipality. To develop four parcels there, I do agree with Member Pringle that it does seem aggressive. On the other hand, we have reports and recommendations from all the regulatory and authoritative bodies. I'm trying not to go by fear of what's happened in the past, and I'm trying to go by the facts that are presented to us. So I think we need to do that. One last question, if I may. So if we were to deny this application and it were to go to LPAT, I'm assuming we wouldn't have a leg to stand on, given that it's this application has met all of the requirements and all the boxes have been checked. Is that a fair assumption, Planner Jen?
Madam Planner, you care to answer that?
Through you, Mr. Chair, to Member Coburn. Should the application be denied by the committee, the applicant does have the option to appeal the committee's decision. And because as the township's planner, I have recommended approval of the applications, the township's legal counsel would need to find a planner that disagreed with my planning report. And then the township would then hire a planner to represent them at the LPAT.
Thank you. Councillor Coburn, did that answer your question?
Probably, it probably is the only way of explaining that or answering that question. I don't expect our planner to have a crystal ball. So are these kinds of things challenged often? And is it that council has the ultimate say? I don't know. I've never been through one of those appeals, so I don't know. I'm sure Jen has answered the question to the best of her ability. Thank you.
Thank you. Deputy Mayor Carlton.
Thank you, Mr. Chair. Councillor Coburn actually addressed exactly what I was going to ask about the fact that if we deny this when it's being recommended and it meets all the criteria, what position do we put the township in? So I think we'll end up putting ourselves in a position of costing more money to defend something that's maybe not defensible. So I think I would have to go for supporting this one. Thank you.
What I said before, and we have a lot of mixed feelings about this particular development. We've had experts submit us reports on every piece, drainage, everything, all through this exercise. We as a committee have to base a decision on something. I'm basing my decision on the information provided by the experts in their fields of what we should do and what we shouldn't do. Our senior planners is advising us that she thinks it should be approved. What can we base our decision on to go against her? I don't know. So all I can do is base my decision on the information provided me to make a decision. That's all I can do. So if there's no other further discussion of this motion, we do have a motion on the floor, and I think it's time that I call the vote on the motion. Show of hands, all in favor of the motion. Opposed? I believe, Madam Clerk, I see 3 for and 1 against. Yeah, I do not see her, so that's why I want it confirmed. So the motion has been carried. Okay. So, Madam Planner, that was the only other new business you had, or unfinished business?
Yes, that is correct, Mr. Chair. And if I may, I know we don't have public announcements listed on our agenda. I would just like to acknowledge that this is Ben's last week with us, and I just wanted to acknowledge him for a wonderful job that he's done this summer, and thank him for his help in the planning department. It was very much appreciated. And just to say that we wish you well for the next semester, and we hope to see you back in the summer. Thanks very much, Ben.
Thank you, Madam Planner. And Ben, on behalf of council and myself, I agree 100% with that. And I've never, ever come across such a bubbling planner my whole life. And you got a great personality, and thank you.
Well, thank you.
Then Jen comes after you. Then Ron. Anyway, our next meeting is September the 20th at 5 o'clock. If we have no other business here tonight, I'll ask for adjournment of this meeting. Moved by Councillor Pringle, second by Councillor Coburn, that we adjourn. Show of hands, all in favor. We're now adjourned. Thank you, everybody.